Welcome to the final session of today's program, where we will have a further opportunity to explore the question of investigations with two very experienced and well-situated presenters. They tell me, and indeed it's understandable, on the basis of the quality and comprehensiveness of presentations during the day, that a number of the observations they might have expected to make have already entered the conversation. They are therefore taking on a little bit of ad-libbing and improvisation and gap filling, which we greatly appreciate. Paul McCullough of the Ontario Ministry of Environment and Climate Change is going to lead off.
Thank you, Jamie. So, as indicated, a lot of the topics I was going to speak about have been covered, and I did somewhat anticipate that, which is why I do not have a PowerPoint, because I knew it would probably just be going through it quickly anyways. So what Rosalind and I have agreed to do is are going to go through what we were going to speak about. We've made a number of notes, and it may come across a bit like my 3-year-old daughter when she was learning to speak, where she would just call out things randomly, red, wall, dog, but hopefully, at least this way, we're not covering the same ground. But let me start from giving you what my perspective, where I'm coming from, as mostly a prosecutor. I do other things. I do administrative hearings as well, but today, speaking with my prosecutor hat on, I start from the premise that prosecutions are an essential element of any regulatory regime. And yes, we have the pyramid or the ladder, whatever you want to call it. You will always need that last rung or that last tip of the pyramid. And while the goal is to have everybody be a virtuous actor and comply willingly and voluntarily, there will always be a subset of actors who are either the rational actor, as Jamie Flegel described them, has to be more expensive to pay a penalty than it is to comply. And those rational actors will always think that way. But more importantly, there will always be a subset of bad actors. And you may not think they're out there, but they are. And I've had to even deal with some of them directly. What's worse is they often don't hire lawyers. So when I say I deal with them directly, I've had to deal with them directly. And we're talking about people who write letters to our officers, calling them morons, saying they're not going to comply under any circumstance unless a court tells them to, which means we're only more than happy to oblige. And yes, we will get a court to tell them. And that is what's happened. In fact, that individual spent 4 months in jail and still had to come into compliance, ended up selling his property for $1 to get out of his situation. So there are people like that out there, and you need enforcement for that final tip of the pyramid. But if you're going to enforce, the onus, of course, in our legal system is on the Crown, the government, to demonstrate that an offense has occurred. And in order to do that, you need evidence. You need reliable evidence, and you need admissible evidence. And that brings us to our topic. To get that type of evidence, you need effective investigations. And that's what I'm going to talk about. I'm going to talk about the genesis of investigations. I'm going to obviously focus on the Ontario regime. I'm going to talk about the steps and procedures for how do we, in an investigation process. And then I'm going to talk about some of the more thorny issues as I described. So far, you've heard a lot of the theory, and typically things do work according to the theory. Again, the stepped enforcement, moving up the ladder. But there are situations where it gets much more complicated, and that tends to be the cases where Rosalind and I, as litigators, get involved. It's the complicated, thorny cases. Those are the ones that typically end up going to trial, and those make for the interesting law. So I want to talk about a few of those cases. So as indicated earlier, I'll just go through this part quickly. First contact usually is through an inspector. The inspector, there was a number of reasons given as to why an inspector will make contact with a facility. One that wasn't mentioned, so that the common are the routine inspections, the random stops, complaints, self-reporting, things like that. There was one that hasn't been mentioned. Jack Coop touched on it briefly, but sometimes you do get employees, what we call whistleblowers. And I did want to add that one because I don't think anyone's mentioned that. It is quite rare in my experience. But Ontario does have what we call whistleblower protections, where an employee reports something that their own company has done. If the company takes reprisal action against that employee, the employee can make an application to the Ontario Labour Relations Board. I'm not sure if that's its current name anymore, and seek redress. I just wanted to point that out. Now, you think about an inspection as a site visit, that is becoming, it still is the primary type of inspection, but it is becoming replaced by other things, and in particular, electronic reporting of data. Self-reporting is becoming more common. Examples are in Ontario, we have something called the Permit to Take Water program, where when you take water out of the ground, you have to, when you take more than 50,000 liters a day, with some exceptions, but for most purposes, you have to get a permit. And now it's a standard condition in almost all the permits that, for commercial type users anyways, you have to report your water takings and submit them through so I think someone referred to it as a portal type portal type system. And what the advantage of that is, another example is in our drinking water. In Ontario, drinking water is also regulated through the Ministry of Environment and Climate Change. And the Safe Drinking Water Act, the requirements for testing. Most municipal drinking water systems have to test the water regularly for things like chlorine residual, bacteria, various chemicals. And there are schedules. You have to do it every so often, depending on the size of your facility. That data has to be reported, and not just, interestingly, by the municipality, but also by the laboratory that does the sampling. And that goes straight into a database. And of course, that database is set up. We have schedules, so we know how often the facility is supposed to do it. And if there's a gap, it'll automatically send an email to one of our inspectors and say, hey, this municipality, City of Ottawa, missed its E. coli testing on this date, and that will immediately trigger an inspection. So that's one way where the government is trying to make more efficient use of our resources. We don't have to look through hundreds and hundreds of pages of data. We now have computer programs that are going to start doing some of this for us. So my first little aside, somebody had asked a question about social media and internet. Not so much social media, but internet is another. I know of inspectors who do use the internet. Go looking on, in Ottawa, these use classified sites. It's called Kijiji. I think out in British Columbia it's called Craigslist. They have found some very interesting things for sale on these things. Pesticides is one of the more common examples. Ontario now has the cosmetic pesticide ban in place. Well, guess what's been for sale on Kijiji? And guess what's stimulated a call? So we do some of that work. And somebody asked about sentencing. Can you, I'm going to talk a bit about sentencing later, about publishing, getting corporations to publish things in their annual reports and things on the internet that they contributed to act. But one thing the ministry does do under, again, the Safe Drinking Water Act legislation, because it's a newer piece of legislation that it helps, is we have something called a chief inspector who publishes a report, and municipalities get report cards every year as well. After they're inspected, a ministry will publish report cards showing how many tests they missed and any other things that came up. So there is some move to try and get more public information out there in limited areas, but not, I think you'll see more of that happening. So any of these can lead to inspections. After an inspection, you've already heard about the various options that an inspector can pursue. So I won't go through those, but what I do want to focus a bit more on the inspection versus investigation divide, because you've heard a number of people referenced it. So an inspection, the key component is that the inspector is there to determine compliance. And the inspector usually has a myriad of choices as to what to do when he or she gets there. Voluntary compliance, orders, warning notices, what we call a violation notice in Ontario, possibly administrative penalties, orders, and referring a matter for investigation. And while an officer may have a suspicion that an offense or a violation has occurred, that is not sufficient to turn an inspection into an investigation. And the cases that Fred Mapes mentioned, the Jarvis case makes that clear. There were a number of factors in that case, 7 different factors, and that is only one factor. And they actually downplayed that factor as being one of the less important. There was a reference by Katia about the perception that a lot of inspectors are viewed as being bulldogs. They're there to look for something. That's actually not my experience. Most inspectors can't be more happy to go and do an inspection and find everything in compliance. And why is that? Because if they find non-compliance, it's a lot of work, right? And they have enough work, believe me. So they're happy as can be to do an inspection and find everybody, the person's in compliance. I'm not, for a second, they're not going to turn their head at anything. They know their job, but they want to find people in the compliance, and they want to bring them into compliance if they fit into the lower tier of the pyramid. So that is the inspection side of things. An investigation, on the other hand, the predominant purpose, and in Ontario, it's pretty much the sole purpose, because we have the separation between inspectors and investigators, is to determine whether enforcement action should be taken that will result in penal consequences, and that's almost invariably laying charges. And that is the sole, I won't say sole, because inspectors do some other things, but that is their main purpose by far. Their primary purpose is, am I going to lay charges against this facility or not? Now, other agencies do not have that distinction, and that might be one of the questions we can discuss at the end, is the pros and cons of having two agencies versus one agency. From my point of view, for simple matters, it's better to have just the one agency, because sometimes our investigation, all it is the investigator getting a statement from the inspector, assembling that into what Fred Mapes already talked about a Crown brief, and submitting it, in which case, well, the inspector could just do that, him or herself. Where I think the two branches really is an advantage are the really complicated cases, and where there is ongoing violations as well, and I'll talk a bit about that later. I did want to mention that our investigators don't only get referrals from inspectors. They do their own, what I'm going to call blitzes sometimes, from where they will go out. The most common I've seen are waste companies. They will park themselves outside of a landfill site, and as the waste companies come in, they will check all their paperwork and make sure they have the right insurance, the trained driver, there's various documentation that has to be in the truck. They will do that once in a while. And they will do joint inspections with other agencies, Ministry of Labour in Ontario, regarding asbestos, for example, because there's occupational health and safety requirements for employees of companies that are removing asbestos, and then there's waste requirements under our legislation. So we have done joint work with them. I haven't seen it in our organization federally, but I know the Ministry of Natural Resources has done, you saw the pictures of the turtles earlier. I know that our conservation officers have done joint work with the federal government on endangered species and I don't know what the legislation is, but the species that you're not allowed to import from other areas. So I'm going to go on to talk about the investigation process now. So once a matter is referred to an investigator, what happens? You heard Fred Mapes' response our conservative position is that once a matter is referred to the investigator cannot use the inspection type powers. Can no longer do warrantless searches, can no longer question people and compel them to give evidence. The investigator now must either get consent or some sort of judicial authorization. But that's only if you want to get information from the target of your investigation. There's all sorts of information that you can get elsewhere, and that's what most of our investigators do. Typically, so there was a question, I think it was up front here, asked, does the inspector hand over the file? Not exactly, but the inspector will do a long statement detailing his or her involvement, will provide copies of all of his or her notes, photos, any documents obtained, that will all be provided, okay? But it's not really the file per se. And then the investigator will usually go through the file because for some of these facilities, we have files going back 20, 30 years. So you have to try and go through and make sure, and this has unfortunately happened, where 20 years ago we wrote a letter saying you can do what you're doing and somebody has never seen that letter. So guess what happened? We did have a case where defense counsel chose, some defense counsel, rather than presenting that letter ahead of time and saying, could you please withdraw the charges, thought it would make a bigger impact to spring it on the first day of trial. And unfortunately, we then had to withdraw the charges, which is what we would have done anyways. So there is that aspect to it as well. We have to go back through the file, but we will not typically disclose an entire file, which can be, boxes and boxes, but we do get requests. And I have also arranged for counsel to come, defense counsel to come to our office and go through it in a boardroom. And, if you find anything, let me know that you think's interesting and you want copied, it's yours, rather than copying it all and then not being anything of any relevance. The investigator will then, if there are other people who are not the target of the investigation, seek any evidence. So victims or complainants, eyewitnesses, neighbors are all interviewed when there's discharges. We always ask to have employees. You heard Jack Coop's response to that, but we will always ask if any employees want to give statements. Sometimes there's subcontractors involved, so you'll ask the subcontractors whether they're willing to give any evidence, and then other agencies, of course. If another agency had to respond for whatever reason, fire department, police department, conservation authorities, often there are other agencies that are involved, so we'll often get statements from them as well. And I was going to talk a bit about employees, but I think Jack Coop covered that quite well. Our rate of getting employees to talk to us is not high. I'll just leave it at that. Unless the company has sort of wants to present, and I'll get to that in a bit, but generally we do not have a lot of employees that want to, and you can understand, they worry about their job, they worry about loyal, they're loyal to their employer. So I in my experience, we haven't had many. There's also, the company often has approvals and licenses and so forth and had to file applications for those. It's amazing the amount of helpful data you can get from the applications they filed. Now, those are often in a separate branch down in Toronto called our approvals branch. So we'll often ask for that file to be either copied and scanned, or they'll go to Toronto and go through those files, and there's all sorts of reports and things like that, which give information about the processes that the company's using and so forth. So that'll be part of the investigation. If it's an ongoing offense, our investigators will use surveillance. We have authority to use things such as tracking devices. I know of investigators who have set up webcams outside of premises looking for certain things. And in an investigation, also nowadays, more and more I'm finding you have to get into the corporate side of the defendant. There's subsidiaries, there's limited partnerships, there's business names. You have to do all of that search as well. And that's a key part of an investigation. And then subcontractors. I mentioned subcontractors. Key is to try and get copies of contracts to know who's responsible for what. And that's a key part of an investigation as well. If the case involves a discharge of some sort of a contaminant or some sort of engineering issue, then you often have to get a scientist or an expert involved as well. And the conference last year, experts was one of the main topics. There's a number of excellent papers on experts, so I'm not going to go into experts. All I'll say is from the investigation point of view, investigator has to be very careful to engage the expert as an independent expert. And because we're often using government employees as experts, which the courts have upheld as acceptable, but there are some rules. And the rules are that the expert is still independent, not there to make the investigator's case, but is hired, not hired isn't the right word if it's a government employee, but is brought in to provide an independent, objective opinion based on certain evidence, and that the investigator doesn't sway the expert at all. And in the paper that I provided, there's a reference to a case that has set out where that's acceptable, and the expert will be accepted as a expert before the court. And there's also a case, the unfortunate opposite, where an expert engineer initially brought in decided to start doing his own sort of investigation, collecting some of his own evidence, started contacting some of the subcontractors directly, and the court determined that engineer, I'm really high level here, I haven't read the case, but it was a Ministry of Labor case, and it's referenced in the paper, and that expert was disqualified at trial as no longer being objective, but had in fact become part of the investigation. So that's something our experts and our investigators have been trained not to do. And then Jack Coop mentioned the Syncrude case. It's the case with the ducks out west, where the employees did give statements, and those statements were just entered into evidence. And that is something, in fact, I just had a case recently where that did happen again, where employees and a company do choose to cooperate, and I'm just going to get into some reasons as to why a company might still do that. But we will try to use those statements directly sometimes, rather than call the employee to even testify, because all the information that's needed is in that witness statement. So why would a company do that? There's 4 reasons I can think of. One, you want to convince the investigator that the offense didn't actually occur. That's rare, in my opinion. If we've got to the stage where we want to interview employees, my sense is there's enough evidence, probably the offense did occur, at least the actus reus. The second reason is the more common. You want to try and convince the investigator that you exercised all due diligence, and that is quite common. And that's when a company will make its employees available, and they will lay it all out and say, this is what happened, but here's why, and here's all the things, the steps we took, and there's no way we could have avoided this. 2 other reasons, Jack did mention, you want to avoid being the subject of a search warrant, because search warrants are very disruptive, and search warrants can find more than sometimes even the investigator knew was going to be there. Whereas sometimes an investigator will say, I'm just looking for these documents. The company may agree to provide those documents and avoid the search warrant. Or some companies have done that under what I call a friendly search warrant, where the documents are put at an office, we know they're going to be there, we show up, the search warrant has a list for those documents, and the investigator will just take those documents away. And finally, cooperating with the ministry investigator is a mitigating factor on sentencing. So that, again, is a strategic decision that any company has to make when they're the subject of an investigation. If they know there's a good chance they're going to be convicted, they might want to start thinking ahead at the investigation stage. And again, that's something to discuss. I think Jack went through some of those considerations in his presentation and had some excellent slides on that. However, when the company does not want to cooperate, Ministry of Environment investigators will get a search warrant and go in and look for documents and other evidence under a search warrant. There is a test. It's not a particularly high test, but but it is on the onus to present evidence to a judicial officer, usually a justice of the peace, that there are grounds for the search warrant, and then can go in looking for the evidence. And some environmental statutes, like the Environmental Protection Act in Ontario, have something called inspection orders as well. And our investigators have used that to go into a facility. One example is to take an expert engineer with them to look at how the piping and so forth was set up, to see if it conformed with the plans that were originally for that facility. Obviously, the investigator wanted to get a good sense of whether the company had a due diligence defense ahead of time, and compliance with a plan would have been, and of course it turned out they didn't build it in accordance with the plan, so that was very helpful information to know. So that's the search warrant, or sorry, the investigation process. I just have some notes of comments some people made. Jack Coop did mention the limitation period. In Ontario, it's 2 years. However, it's 2 years from the date that the ministry director becomes aware of the offense. So there is a discoverability component to that limitation period. Also, it's the ministry's position that if you have a continuing offense, so you're issued an order and you have to comply with an order, and you don't comply with the order, every day that you don't comply with the order is another offense. So the offense is continuing, in which case the limitation period keeps getting extended until the day that you comply with the order. There are some cases both ways on that, but it's our position that there are enough cases in favor of that to take that position. And I think that's all I wanted to say about investigations. Fred Maves talked about what happens at the end of the investigation. It's put into a Crown brief and submitted to the Legal Services Branch. I won't go through that again. I will add that advice that is given on the charges is treated as legal advice. It's subject to privilege. And some officers will come and seek legal advice during the investigation as well, and that, again, is privileged. So Environment Canada had some stats, so I figured we better get some stats. So we managed to get some stats in time for this presentation today. Right now, the past few years, Ministry of Environment in Ontario, Ministry of Environment and Climate Change in Ontario has averaged about 200 to 250 charges. It's been fairly steady. It's a slight decline from, I think we got up over 300 for a while in the mid-2000s, but it's been fairly steady. And there can be various reasons for, sometimes it's just incidents. As Jamie Flegel described the legislation, there were just a bunch of spills one year, and that was right in the middle of that spike, so that's part of it. Of the 200 to 250 charges that are laid each year, there is a close to 90% conviction rate, or slightly over 90% conviction rate at any time. 75 to 80% of those would be guilty pleas, which I think shows that our investigators are probably doing a pretty good job. It shows that when they submit a brief, they have good reason to believe that a charge can be laid. And of course, it goes through the screening process, so that also supports the ministry's screening process. Of the remaining 20%, let's say, 10 to 15% of those would go to trial, of which I would say about 10% are result in convictions, and about 5% result in acquittals. That's just based on some unscientific work I did when I was doing a presentation a couple years ago. But fairly good success rate. And then there's an other 5% where we withdraw the charges for various reasons. Could be that the Defense Counsel has presented more information on due diligence. We realize that actually there's a good due diligence case to be made. There can be just other reasons as to why to withdraw charges. Sometimes witnesses disappear, evidence, that's another reason. Sometimes we don't have the witnesses we need. I did want to comment a bit on sentencing. On minimum fines has come up a couple times, and I agree. There was a comment made. Because of the minimum fine provisions that are happening and are now happening at the federal level, we have seen more trials in Ontario than we ever have before. as companies realize that the minimum fines escalate as you get more convictions. Companies are realizing it's going to cost them a lot of money. So they're defending more. That is something we've observed. And I've noticed more interesting defenses such as motions. And when Katya was speaking, she mentioned, some people say, why me? And one of the defenses that some people try to run is something called selective prosecution. So if your police officer is sitting there and 5 people go by at 120 kilometers an hour and you're the 6th person and suddenly the police officer says you, one argument is, well, you didn't go after the other 5 or 6 people. That defense actually is not successful. There has to be some motive of bad faith for that to happen. So it has to be that your car was blue and everyone else's was red. Well, okay, maybe then. But if it's just random discretion, that defense isn't overly successful. Unless, again, there's bad faith. So if the inspector knows somebody at a facility and doesn't like them for some reason, that would be the sort of thing. There was a question about creative sentencing in Ontario. Ontario does not have the explicit authority that the federal government now has in some of its legislation for things like getting corporations to publish newspaper ads saying we're bad, other sorts of things like that. However, we don't have explicit authority to have money paid into a fund to do certain work as well in the federal government, and that's common. I've seen in a number of convictions recently in the federal government. We do have some limited authority for court orders to address damage, so that it has to be directly linked to redressing the damage. We can get probation orders. The probation order a condition must be limited to ensuring that the company does not commit the offense again. By the way, corporations can get a probation order. That has been upheld. And the problem is who enforces a probation order, whether it's our ministry or whether it's another ministry is a bit of an issue. The Ministry of Environment in Ontario does issue something called court bulletins about convictions on its website. It will publish the names of corporations. I believe it'll publish the name of an individual, but the individuals will only be up for a time-limited period and then will be taken down. And that's due to some privacy concerns that have been raised. How are we doing for time? Okay. So I will finish by just, and this will be something I think we could have questions about. There was a question from one of the federal prosecutors earlier about the Jarvis and Ling inspection versus investigation debate. And Fred Mapes answered the question. What I think is the current advice that we give is that once an inspector meets all those criteria in the case called Jarvis and it becomes an investigation, the evidence that's collected by the inspector after that cannot be used by the investigator. However, and it's a very interesting however, there are 2 cases that suggest the courts might be willing to recast that. And one case is called Nolet, N-O-L-E-T. It's a Supreme Court of Canada case. The site, I don't have the site, but it is in the paper I do. 2010, Supreme Court 24. And in that case, a police officer stopped a truck in Saskatchewan to do a Highway Traffic Act inspection, started looking into the logs of the driver, got suspicious, went on to search the cab, which there's a privacy interest because the cab has a bed, but found a bag that he thought had logs in it, opened up the bag, and in fact it had $100,000 in small bills, got more suspicious, opened the truck, looked in the truck, and it was empty, and wondered why there was an empty truck because they only had the right to go to Ontario. Looked at the truck again, realized and started knocking and found an empty, a hidden compartment with $1.5 million in marijuana. And anyways, the Supreme Court allowed all that evidence in. And what was interesting is that the court distinguished that case from Jarvis and talked about something, a continuing regulatory purpose test. And where somebody has a continuing regulatory purpose And as long as at each step of the way, you're just progressing in a stepwise manner, that's fine. Now, that was a police officer, and the court described the police officer as being in an adversarial relationship with the truck from the moment that the truck was pulled over, and distinguished it from Jarvis in that situation. It's interesting to see how that case would translate into somewhere like the Ministry of Environment in Ontario, where we have the two branches, as compared to the Ministry of Environment and Climate Change federally, which only has the one branch. So that's a case. I think that's going to be some evolving case law. And there's another case from British Columbia. The prosecutor referred to it as mission development. I call it Larson because that's how it's cited. And in that case, the issue is, what is the right to privacy that corporate entities have in their operations? And in that case, it was an abandoned industrial facility, and the Department of Fisheries and Ocean officers went onto the property, and it was found to have a very low expectation of privacy. The gate, there was a gate and a fence, but the gate was unlocked, and it really wasn't, there wasn't a lot to keep anybody off the property in any event. So in that case, when the observations of the officer of changes to fish habitat were again permitted. So I think the courts have shown an openness to how those tests will be interpreted. Ultimately, my gut feeling is is the officer operating in good faith or bad faith? If the operator is there, or sorry, the inspector, if the inspector is there in good faith, at what point does it become an investigation? As long as the inspector is operating under good faith reasons, I think the government, from a government perspective, we're going to have good success in getting the evidence in whenever there's any sense that the inspector is doing things for improper motives. It's going to be hard to get the evidence in. I'll leave it at that.
So the two speakers in our final session have suggested that they would take questions at the end of the two presentations. Paul, that was enormously informative and varied and wonderful, detailed insights. I have to confess, I was stuck at the riddle posed by your daughter at the outset. Red wall dog. So here's my best shot. Red, the warning light is flashing. Should we be checking it out? Wall, is the impermeable liner really foolproof? And because it's underground, how are we going to find that out? Dog, did the dog bark in the marsh suggesting out-of-season hunting? Anyway, I think she's on to something. Our next speaker and final speaker for the day, Roz Cooper, is going to offer some of her insights from a corporate perspective in relation to a number of the issues I think that Paul has addressed and that otherwise came up during the day. Roz.
Thanks very much. So, last speaker of the day, first of all, I want to say it was a thrill to be introduced by Jamie, because Jamie was my professor in law school at the University of Ottawa. So after having listened to him give many a lecture and very interesting lectures, a bit of a thrill to be introduced by him. So thank you for inviting me to speak today. My topic is dealing with investigations. As some of you have probably guessed by now, Jack Coop stole my topic. Thank you, Jack. But I will be doing a variation on the theme. I will be talking a little bit about doing investigations. I'm going to be talking about some other issues as well. Jack's topic was collecting evidence. I'm going to talk a little bit about that. And then I'm going to talk about some topics that my colleagues at the back there shot at me just before I came up. So Janet Babechko and Jennifer Fairfax gave me some ideas. So it'll be a bit of a freestyle mixture of everything, and I do welcome questions. One of the things they said to me is tell some of your stories, some of your war stories from some of your cases. So I am going to be doing that, and I'm going to start off with a case that most people probably have heard about but don't really know how it came about, and that is the Bata case. So you'd be hard-pressed to find someone who practices environmental law that hasn't heard about the Bata case. But what people don't necessarily know, and that I know because our firm was involved in that case, is how the whole investigation started and how those underground tanks were actually discovered. Do people know the story of how that happened? Okay. So that is a classic example, and it's something that Jack referred to, of the investigator, or in this case it was an inspector, comes to the facility, and they're coming to the facility just to do an inspection. So they go to the BATA facility in Ottawa, Ontario, to do their inspection, to meet with some people at the plant. They get to the gate, and there is nobody there, and the gate is wide open. They decide they're going to come in. They do a little bit of a walk around. There's nobody there. They don't encounter any employees. There's no process. They walk around the entire facility, and in particular, they walk out back. And when they're walking out back, they discover some of the evidence that eventually leads them to find these buried tanks. And that is how those tanks were discovered. That is how the charges ended up being laid, how enforcement ended up being called in, and how the whole BATA case came about with all of the issues that came forward from that. So, lesson learned from that case in terms of dealing with investigations, dealing with inspections, is being prepared and anticipating things that might happen and managing those issues accordingly. So I want to say at the beginning that all of my clients are virtuous. None of them fall into any other category. So any comment I make that appears not to be that would be somebody else's client, and the stories that I tell about the virtuous clients are all mine. So, it's interesting because on one of the slides that went up, there was a reference to an informant, that sometimes the ministry will find out things from informants. And one of the cases that I got involved in where I was present during an investigation by the ministry was a case where a former employee of a company had used his iPhone to tape what he called a discharge of material into a local creek on this massive property owned by my client. So this former employee videotaped what looked like to be water spewing out of some pipe and heading towards a creek. And this was provided to the Ministry of the Environment. The Ministry of the Environment began an investigation. They decided they wanted to come out to the facility. They scheduled interviewing a bunch of employees. A company called me out as legal counsel to come and figure out what was happening and what was this allegation about this water spewing, because they had no idea what it was. And interestingly, at the end of the day, it turned out there were two things that were interesting. One was that on this particular facility, it is prohibited to carry cell phones because of confidential, proprietary, and other information. So one thing the company couldn't figure out is why this individual was carrying around a cell phone and filming things. But the second piece of it was they couldn't put their hands on where he was in the facility or what it was that he was filming because they didn't have anything like that at the site. And after several visits from the investigator and many, many months of trying to investigate and look into it, it turned out that the employee had essentially fabricated the entire thing. So it was an employee who had been terminated by the company, was very unhappy about that, and suggested that there were improper environmental habits or practices at the facility and called in the ministry. So sometimes things come through informants, but sometimes some unusual things come through informants. And, the amount of effort and money and private investigation that the company had to go through to try and respond to this and try and figure out what this employee had alleged had occurred was quite significant. And so just a caution about evidence and making sure one examines evidence very carefully and understands what it is. So in terms of investigations, and Jack talked a little bit about this, but I wanted to give you some thoughts as to, why different lawyers have different views about how to handle investigations. And I've been doing this a while, and I've learned there's sort of different camps on how to deal with investigations, whether it's from the Ministry of the Environment and Climate Change, or whether it's from Environment Canada or Fisheries or whomever. And I've dealt with all of them over the years. But there are some lawyers that have the view that if a matter goes to an investigation, and an investigator is at a facility, that the lawyer has no place there at all. And I've heard criminal lawyers make that statement very clearly. You should never be sitting in on an interview. You should never be participating. You wait until the charges are laid, and then that's where defense counsel comes into play. There are others who are on the complete opposite side of that spectrum, which is as soon as there's any indication there's an investigation, the lawyer has a role to play and that the lawyer should be involved and be steering how that investigation proceeds and be providing advice along the way. And then there are those that are kind of in the middle. They have very strong views about participating in interviews, specifically not participating in interviews, and then they have views that you should otherwise be present in guiding the investigation. And my answer is, and my practice is, it very much depends on the specifics of each case. And there is no one size fits all. You have to look at what is it being investigated, what is the company's philosophy on an investigation, and you have to look at all the factors that will drive your conduct and how you handle it. So let me give you some examples. I do have, amongst my various virtuous clients, a number of them that have excellent relationships with the ministry. And they have very open relationships. They have good relationships with abatement officers. The thought that they would tell an investigator to go away or that they're not going to participate in an investigation is completely foreign and unacceptable to them. So even if you were to say you don't have to do this, and the investigators will sometimes say you don't have to participate in this investigation, the company, just as a matter of course, will always want to be seen to be cooperating. So I've had very many clients say to me, I understand what the risks are. I understand that they're here to collect evidence. I appreciate all of that. I still want to cooperate in some way. And then the role as defense counsel really involves trying to steer the client through that process, trying to minimize opportunities for things to go wrong, trying to make sure the record's very clear, but there still is absolutely a role for counsel to play. There is the other extreme where clients will say, you know, if I don't have to let that investigator in the door, I am not going to let the investigator in the door, and you do whatever you have to do to keep them out of the facility. And then, of course, your role is going to be completely different. So I am less in one camp or the other. I think you've got to look at the particular circumstances and what's happening and then decide how you want to proceed and what advice you want to give to your client, depending on the circumstances. There is a lot of discussion, as I mentioned earlier, about sitting in on interviews. And there are some lawyers that get very, very nervous about the prospect of sitting in during an investigation interview. Others don't have a problem with it. Again, on that point, I am in the, one size does not fit all. You really have to evaluate the circumstances. The one thing I absolutely caution against, and I have seen some lawyers do this, is suggesting that you are counsel for the employee. That is a road that I will never go down and a road that you must be very, very careful of. So why do lawyers do that sometimes? Sometimes lawyers will do that because the investigator will take the position, and I have seen them do this, that unless you are counsel for the individual being interviewed, you don't have a right to be in the room. And sometimes lawyers who think that they should be in the room or they've told their client they're entitled to be in the room will get very nervous about having to say, I wasn't allowed to stay. So when the investigator will say to them squarely, are you counsel for the employee or for the company? They'll sometimes say, oh, no, he said I can be here and I'm advising him as well. I would never do that. If you wonder why you shouldn't do that, there's an old case, the Laidlaw case, where an environmental lawyer was removed as counsel of record due to conflict because he agreed to be the counsel for the employees as well. And when charges were laid and the matter was going to trial, the court looked at it and said the perception there is of a conflict. That lawyer who's now defending the company will be cross-examining the employees that were his clients apparently during that investigation interview. So, you will get bounced. It's embarrassing. All the other reasons why my view is you never say yes to that question. I've been asked that question on many occasions when I'd like to sit in on an interview. And I will always say I'm not counsel for the employee, I am counsel for the company. And if the investigator suggests I'm not entitled to sit in because of that, I will leave. I would rather leave than be there and be deemed to be counsel for the employee. In most instances, I have found, and I'm not sure if I should say this in front of the ministry, but most investigators are pretty good about it. They actually don't mind if I sit in on the interviews, even as counsel for the company. So I also feel like I don't have to be counsel for the individual to get in the room. I think sometimes if you're just very open and say, I'm here for the company would like me to sit in on these interviews, if that's what you choose to do in the circumstance, most investigators will say fine. I would say that, out of all the ones I've done, there's been many over the years, I've maybe had 2 instances where the investigator said, I rather you didn't if you're not counsel for the employee. They usually let me stay. So why would you want to be in there? Again, we talked earlier about should you be in there, should you not be in there? So I often like to be in there for a few reasons. One is that I feel that I can be helpful to the investigation. And how can I be helpful to the investigation? Well, whether or not investigators like to admit it or not, there is a bit of an intimidation factor there. Okay, they're sitting down with an employee. For the average employee, they have no idea what's going on. They've never been interviewed before by an investigator. They liken the person to a police officer. They assume someone's done something wrong, and they're very, very nervous. And I just find if you have somebody else in the room that kind of knows what's going to happen and tells them beforehand what's going to happen, you know, the investigator's going to walk in, he's probably going to ask you questions, he or she might take notes, maybe they'll record it. Just the familiarity makes the person a bit more comfortable. Why does that matter? It matters because they're going to do a better job listening to what the questions being asked are, answering the questions properly. They're more comfortable. Things go more smoothly. It is a much better approach than having somebody go in cold and be very intimidated and concerned about what might happen. The other reason why I like to be there is because I can often assist in clarifying and in making sure that the question that's being asked is understood and being properly answered. I can't tell you how many times I've been sitting in the room and an investigator, and it's no fault of the investigator, but he or she will ask a question and maybe it's a very open-ended question or it could be misinterpreted, and I can actually tell in the answer that the employee has gone completely away from what the investigator is even talking about. Sometimes a third party listening to that question and answer can help facilitate the discussion in terms of saying, well, did you mean that day or do you mean from before? And all of a sudden, oh, no, we were talking about before, not that day. So it's very important to have that extra person listening and making sure everything is clear. The other thing is although, again, you're not giving advice to the employee, you can help in certain respects. And a good example for you is often after a statement is taken from an individual, the investigator will say, would you sign this for me? Well, usually when an investigator says that, the employee has this panicked look in their eye, like, what is going to happen to me if I do, and should I, and I don't know what to do. Now, again, you're not there to give legal advice to the employee, but even just being able to say, like, here's what this means, here's what you're being asked to do, this is what it means when you sign a statement, is very helpful and, again, can facilitate the process. More substantively, though, why do I want to be there? I've had a number of situations with clients, again, my virtuous clients, who have really good due diligence defenses. And I have found rather than, stringing it out and having an investigation take place and a brief prepared and someone in legal services branch says this looks good and you end up, either at trial or on the way to trial, and then you sort of put your due diligence defense out there and the ministry goes, oh, if I would have known that, I wouldn't have gone ahead. I rather do that right at the initial stage, especially if the client tells me what happened and I can see that there is a really good story to tell. I don't see any point in waiting. That doesn't service their needs, and it also wastes the ministry's time. So my strategy is I want the story to come out in the investigation. I want to make sure it comes out in a way that the investigator can understand, really absolves my client of liability. So why wouldn't I put that out there then? So that's another reason why I might want to sit in. So I think you kind of have to look at the circumstances as to whether or not you participate or don't participate, but there's a lot of good reasons to be in that room. And so for the counsel that say, never, never, never would I ever participate in an interview, I come back to, I think you have to look at the individual circumstances and make an assessment on that basis. I think you also have to look at, making sure if you do sit in on the interview that you do understand the background. So one of the things that I always do like to do, and I think is very important, is to make sure that you're not going in what I say is cold, right? You arrive at the same time the investigator arrives and you have no idea what happened or why they're really being investigated. You should really have a complete understanding of what's taken place, why it took place, and understand the background, because that is the way that you're going to be most helpful. That's the way you're going to be able to point out that defense that might be lying there. That's the way you're going to help your client in the best way possible. So again, those are some approaches with respect to that. I mentioned the issue of perhaps getting charges not to proceed at all, which is a very important one. But I think it can also, if nothing else, even though you're prepared and you know the background, if you go into that investigation, you will also gain a lot of information about the case. And that can only help you as you go forward with the case, no matter what they intend to do. You're going to have a better understanding of what it's all about. So that's another suggestion of mine. We talked, I think somebody else talked about the obstruction issue. It's a very difficult line to walk in terms of obstruction. I have had investigators say to certain individuals, you know, if you don't cooperate with me, or if you don't get me this, or if you don't do that, you know, you could be charged with obstruction. It's happening less and less now. And in fact, I'll tell you the way investigations usually unfold, and they all seem to unfold the same way these days, so there must have been some training going on at the ministry. But usually you will get some sort of contact from the investigator saying, I am investigating the following offense. And they will be very specific as to what the offense is. And they'll say, I want the following information, or I want to meet with certain employees. Sometimes they'll even tell you who the employees are that they'd like to meet with. And they've gotten it from various sources. But they're quite specific. And I find, in fairness, all of those contacts now are followed with, and they're usually by email or letter. In bold print, it always says, you are under no obligation to cooperate or to provide this information. It also says, if you choose to cooperate or provide the information, it can be used against you. I like that. I like it for a couple of reasons. One is that, you know, this struggle that my clients tend to have from time to time as to, do I cooperate, do I not cooperate, what does it all mean? It's really there in black and white. It says it quite clearly what the risks are and what the benefits are. Some of them will even put in a line that says something like, if you have a due diligence defense that you'd like to offer, this is your opportunity to do that. So they're quite specific about what they're looking for, what the consequences are of you providing information. And so there's no confusion about that. And in fact, it leads to an avoidance of confusion as to whether it's an inspection or investigation, which is something we've been talking a lot about. And I think years ago, there was much more confusion on that front because an investigator would show up and say, I want to talk to some people. Now this happens in advance of them ever coming to the facility. They're advising you what they're looking into. Sometimes they'll even cite the section of the statute they're investigating. So it is helpful in knowing what their position is. The other thing I wanted to mention, because I've been focusing on Ministry of Environment, is, as I mentioned earlier, I have done Environment Canada investigations and all sorts of officers in different environmental realms, wildlife, etc. Environment Canada officers in particular, and some of the fisheries officers, tend to come to these interviews not only in gear, which I'm, you know, with all the uniform, but with guns sometimes. And I've had 3 or 4 of them where they've asked my clients to meet them at their office, and they show up with, you know, guns in the holster. And that can be very, very intimidating for a client. So again, back to my what purpose can you serve? Even as you head up into the office to say, by the way, if someone greets at the door and is armed, don't panic. That's just the way they conduct themselves. They also deal with wildlife issues. They're up north, out and here and there. Just even telling a client what they might expect is an important purpose and helps sort of facilitate everything and make it a little less intimidating than it might otherwise be. Paul mentioned a few times about how information can go to the ministry without them even doing an investigation. And a classic example is spills report. So as most of you know, you have a spill, you call up SAC, spills action, you tell them what happened, how much you spilled, etc. Those, you know, calls are recorded, they're available as evidence. The ministry knows whether you've had a spill. They know all the details from what you've left on the recording. There are other situations, and again, you know, Paul describes some of these where your approval or other requirements mandate that you send in information, test results or reports. Oftentimes, the ministry is able to proceed with their charges simply on the basis of that information. They don't even need you. So I've had several where there is a spill or a charge for late reporting, for example. They don't really even need to come to the facility to take interviews or do interviews with employees. They know this already. How do they know it? Because they have it recorded from the call to the Spills Action Center, or they have the data from a report that has to be submitted. I will say that as defense counsel, it does create a bit of a tension. And the tension is, and I've had this debate with many people, but, it's information that you are mandated by law to provide to the ministry. You are complying with your legal duties to provide the information or to report a spill or do whatever you're required to do. But there's also the strong possibility and the likelihood that the ministry will take that information that you're legally obliged to provide, and then that will form the basis of the evidence that's used against you in a prosecution. Unfortunately for us, that was challenged quite some time ago in a decision many, many years ago, and was challenged unsuccessfully. So we are where we are, but I do find that tension still exists, and clients will still say to me, how is it that we have to provide this to the ministry, and then the ministry can take the very information we're obliged to provide and we're providing in accordance with our documentation and turn around and charge? And why isn't there some other process to penalize us for whatever infraction we've committed other than a charge? So, and I guess that gets to some of the discussion we had this morning around, creative sentencing or other options beyond sentencing or beyond convictions in the courts to deal with some of these things. So I just wanted to cover off that as well. I think the other thing that is important in terms of public complaints I wanted to talk about a little bit, because a lot of the matters that I do get involved in will be generated not so much necessarily from what the ministry finds out from an abatement officer, but more from the public complaining about something. They notice some, sheen on the local creek, or they had some odor emissions that were bothering them, or there was dust on their cars. Those types of things will absolutely prompt a call to the ministry, and the call to the ministry will in turn prompt likely an investigation. So, one of the things that I will often say to clients is to get out ahead of those types of incidents if they have them with the local community. Because oftentimes if that call to the ministry can be avoided, where someone, you have 5 people in the neighborhood calling in and saying my car is full of dust because this company spewed something out, then that will be helpful to you. It'll be helpful to you both in terms of the ministry's desire to proceed, even if it learns of the incident, but also the ministry won't be getting those 5 or 6 calls from people complaining about whatever it is that happened. So I know sometimes companies want to hide when these things happen and be in denial and pretend it didn't happen, but it's very important to try and get out in front of it and to deal with it with the ministry. I'm being told to stop, and I did tell you that one of my problems is stopping. So I will stop there, but I'm happy to answer questions.
Just hand it back to the Okay.
Probably more for you.
I don't know. You got it. You keep it.
I think we have a few minutes for questions at the end of the afternoon. A couple have come in, and I'm going to ask them on behalf of the online participants who sent them in. First, a question for Paul. If you could be granted one thing to make compliance and enforcement in Ontario more effective, what would that be?
Wow. We could get rid of the charter, but I personally, I've actually said this in lectures, and I've actually advised our inspectors and investigators during education as to why the charter is important. Some of them have said, why do we have this charter? And I've said, well, look at other countries around the world, so I'm not going to say that. One thing. I don't know about the rules of evidence about some of the science, and Elaine's presentation about all of the sampling and all the rules, that can be quite onerous. And I did just have a case where an acquittal was granted because the officer didn't follow. It wasn't one of our officers, it was actually another agency, didn't follow exactly the protocol. And my personal belief was it was a minor breach of the protocol, but the justice felt that it went to her credibility. probably some evidentiary rules about getting scientific evidence in, allowing evidence of that sort to be presumably accurate, and that the defense would have to prove that it isn't. And we do have a rule like that for where the Ministry of Environment Laboratory does the work. You can enter a lab result without the analyst having to come testify, and then it's up to the defendant to prove that the lab result was somehow inaccurate. Something wider on that range would be helpful.
And again, Paul, a short question for you from another one of our online participants, because you raised the issue of making the charter go away. Since we've got the charter, is there a point, is there guidance in the investigative dimension of a possible proceeding when the investigator will provide a charter warning or something along those lines?
Absolutely. Every statement, in fact, the statements, Rosalind said people are afraid to sign them. Most of them now are audio taped. We have little digital audio tapes, and our investigators should, every time, the first 3 questions should be, you don't have to, this is voluntary, you can leave anytime, the door's there, it's, that warning is always given, and if it is, that's for almost anybody, and if it is an individual who there's a good chance will be charged, will be told, all the things that Rosalind said are in that letter are also said beforehand, that this can be used against you and so forth. So yes, absolutely. Whereas an inspector will not. That's a big difference between the inspection versus investigation.
Okay, thank you. And Roz, a question came in for you in the context of potential conflicts when you're acting for the company. Is it sometimes difficult to make a distinction between the company and an individual? And in particular, the questioner says, you're dealing with a manager, you're dealing with a CEO, maybe you're dealing with a director, people who might have the capacity to represent the company, but might nevertheless be subject to individual charges at some point. Is that a challenge?
I think it is a challenge, and it's a challenge more and more as the ministry is starting to charge more individuals, particularly directors and officers, because directors and officers are typically the directing mind of the company. So, to Jamie's point, you would argue, well, aren't they in essence the company or speaking for the company? But they may be in a very different position. So, I'll give you an example of a case that we've got now where the ministry has charged 4 directors and officers. 2 of them have separate counsel, and 2 of them are being defended by me along with the company. And why the distinction is there is because of a slight difference in opinion between the directors in terms of information, right? So you really do have to, and one of the things I did early on in that case is sit down and say, okay, let's figure out whether it's possible for me to defend any of the directors and officers, because it may have been that it wasn't. It's a different charge with a different onus on it, so it is quite different. You have to look at it very carefully. And if there's some that I feel would put me in a conflict position, then you just can't do it. So it's going to be a case-by-case assessment. But I've even had cases, for example, where the company is alleging that the employee did something wrong, right? They have a spill policy and the employee's trained and they've been trained repeatedly and they didn't follow the spill policy and they didn't do what they were supposed to do. Well, I mean, that's an easy one. Clearly, there's a conflict of interest there. But you just have to be careful with those because you never know when the facts are going to turn in such a way that puts you in that position. So you want to be very careful about advising on both. But it really is a case-by-case analysis.
Can I inquire, as virtually the closing element of today's program, if there are any questions from the audience?
Thanks, Jack Coop. I have a question for Paul. Paul, this goes to some of your comments about mandatory minimums. And I'm wondering, first of all, when you're dealing with charges that have a mandatory minimum penalty, as prosecutor, do you have a discretion to accept a plea for less than the minimum? That's question one. And question two is also, do you have a discretion to withdraw that charge as part of an overall plea? Because I think I've heard answers to the contrary from some prosecutors, but not others.
We do have a Crown prosecutor's manual. It strongly discourages Crowns from withdrawing charges when there is a mandatory minimum. And that is my own personal view. We will not withdraw to a lesser charge just simply for the purposes of a plea. Now, you may present further evidence to explain why on a certain charge I don't have a strong case. And maybe one of the other charges, so for an example, I have a number of cases right now where there are discharge of dirty water into silt-laden water, and there are the condition in an approval saying you shall use best management practices to prevent soil erosion and sedimentation. And then there's so that's a violation of an approval. And then there's our Section 14 is the Ontario's discharge prohibition, and that's the minimum fine offense. And we often charge for both. One, the dirty water is causing an adverse effect or impairing water quality, but you're also violating your approval. If I, as a prosecutor, look at the file and see evidence that there is an adverse effect or impairing water quality, I will not withdraw just to get a plea to give a lesser offense. If there are problems with the evidence on the more serious charge, but there still is the approval, then I think there's more room to negotiate in that situation.
I said, Jack, it depends who's asking.
I'm going to let us linger for one more question, if brief, and then we'll close off in the interest of trying to be timely.
A question for Jackie. In circumstances where you do accompany an employee in an interview with a regulatory agency inspector or investigator, and obviously you don't feel that there's a conflict of interest of any kind, or you're not aware that there could be one in that circumstance, do you also, or have you in cases, had a second person with you in addition to the employee who you're with who takes notes, whose function is only to record the questions asked and the answers provided for future reference?
So you're thinking in an interview setting, an investigator's in there, and you're asking, would I have somebody with me to take notes of what's happening?
Correct.
Okay. So you could, provided the investigator agrees with that, say I have somebody that I'd like to be there to take notes. So you certainly could do that. I don't make it a practice to do that. I usually do take notes while I'm sitting there as well, and no investigator has ever said they had a problem with that, but I do like to take some notes. They're probably not detailed, but I take some notes myself. I think if you felt you wanted to bring someone and the investigator didn't object to that, it's certainly open to do that.
Again, most of our investigators are now using digital audio recordings, and they're going to get a copy of the audio, so just for exactly for that reason. So.
One public service announcement. We will reconvene tomorrow morning, 9 o'clock Eastern, for day 2 of this symposium. In closing off the day, I think it would be appropriate to thank not only Roz and Paul for their contribution to this last session, but to all of our presenters over the course of the day, I think, for a very stimulating program. Thank you.